There is growing outrage over how the presiding judge handled the Stanford University sexual assault case of Brock Turner. The 20-year-old Turner was sentenced to 6 months in a county jail for 3 felony convictions. Turner has failed to accept responsibility for the incident in question and instead blamed it in part on a college party culture. Also, prosecutors argue that Judge Persky should have given him at least 6 years. It was the sentence the prosecution was seeking. Now Persky could be removed from the bench in a growing recall effort. In a letter, in fact, to the judge, Brock Turner's mother writes that her son is, and I quote, utterly terrified and traumatized by this. He is suffering and will continue to pay for this for his entire lifetime, end quote. It is just one of the letters and statements that played a huge role, I would guess. Here, CBS News legal analyst Rikki Klieman now joins us for more. Rikki, first to the sentence. Obviously, it has been lined up in the crosshairs since it was handed down 6 months for the incident in question. What'd you make of it?
I think the sentence is shockingly light. However, Judge Persky, who is now being vilified nationwide about this sentence, didn't just make it up. He was given a full and thorough report from the probation office that recommended either no incarceration or moderate incarceration, and that he would have sexual offender registry and that he would otherwise get treatment. The probation office has a very complex set of grids where it works through the characteristics of the offense and the offender. In addition, probation spoke with the victim in this case, and the victim at the time in probation said that she did not want his life ruined. She did not want him substantially punished. What she wanted was for him to learn a lesson, to get treatment, and to express remorse. That also played into probation's recommendation to this court, which is a very different story than what we see and hear in her extraordinarily articulate victim impact statement.
We have seen the statements then on the part of the victim and on the part of the parents, both Turner's mother and father, and certainly the impacts they've played. And you mentioned that she had said she didn't want any substantial impact. However, he had faced up to 14 years in prison. Prosecution was asking for 6 years. It got essentially a tenth then of what it was looking for. It could be argued that when she said, I don't want any substantial punishment for him, still she thought, well, more than half a year.
We don't know what she thought, and we don't know what she thought at the time she talked to probation or when she wrote her really breathtaking statement. But we have to remember it is one consideration as to how the victim feels. There are many considerations in the process of sentencing. It's one of the most complex and critical parts of practicing criminal law on both sides. There is true advocacy that must take place here. The prosecution even says that despite this light sentence, which I don't see how anyone could call it anything other than a slap on the wrist, that despite that, the prosecution doesn't see any need to recall this judge. And I think that that's a significant fact.
Interestingly, it wasn't just the visceral impact, the emotional impact of her statement. In parsing it all, she really takes apart the evolution, if you will, of the defense, pointing out very specifically that initially Brock Turner said that he didn't remember any communication between the two of them at all, that he couldn't remember if consent had been given. And only after more lawyers and, his team had coalesced could he suddenly recall that consent, according to Turner, had been given here. It has made a lot of people look at that and say this is a clear example of white privilege.
Well, I think that there certainly is the example in the sentencing and in the lawyering of what happens when someone has resources and someone who also happens to be an athlete from a very elite school. If we look at his mitigating factor, his excuse that he was intoxicated, well, we don't excuse drunk drivers for being intoxicated when they hurt someone. We don't look at someone's voluntary intoxication as a defense in a case. So the fact that he happened also to be inebriated, well, should that give him a lighter sentence? Hardly so. That would mean that we would then look upon all sexual assault cases at college where we can show that the defendant has been drinking, that somehow he is less culpable? I don't think so.
It's, again, you mentioned it, it's hard to see anything other than a slap on the wrist here. Everybody agrees that it's awful. Interestingly as well, that the jury found essentially that he had lied. I mean, that is what they did not accept Brock Turner's version of events ultimately with regard to consent. So if then the judge in question here uses all means at his disposal to arrive at a 6-month sentence. He's now facing this recall effort, and I know that has now taken this case and its impact to another place for you.
Well, it really does, because there are very few states that allow judges to be recalled. And what that means is usually that a judge has engaged in malfeasance or misfeasance, that he has done or she has done a criminal act, that they have shown up at work and gone on the bench drunk or drugged or sleeping. It's not about someone making a discretionary decision based on a lot of facts. This is a weighing process. You weigh the aggravators and the mitigators and coming up with a decision that is unpopular. If we start looking at society and its ability to use social media and to whip up people into a frenzy, and we therefore start removing judges who make unpopular decisions, I say then we lose the independence of the judiciary. You may not like this decision, but apparently he has been a judge who is highly respected for his other decisions.
Social media can be very difficult here. I know in speaking about this case just this week, I've faced it on Twitter myself that perhaps I haven't come down strongly enough. If nothing else then, do you agree that, as the prosecution has suggested, that if there's one thing to come from this case, it's that a bigger and broader discussion of the culture that we're speaking about has now ensued? Well,
I think that we do need a bigger and broader discussion. The problem is we've been having that discussion for years. And college campuses are fraught with peril because you have young men and young women at the age of raging hormones, and there's alcohol, and there may be drugs, but alcohol seems to be the pervasive problem. This case has facts all in and of its own because you had eyewitnesses, you had those graduate students who came by. This isn't a simple he said, she said. They saw a body of a female that was not moving. When one went to check on her, he didn't even know if she was breathing. That's a very different set of circumstances than the man and the woman go off into a quiet room and it's his word against hers. One thing we know, and we know for sure, and we better get it through the heads of our sons and daughters, is that if a young woman is so intoxicated that she cannot give consent, you cannot take advantage of her. And in this case, she literally did not awaken until hours later.
And thankfully, those two graduate students in question came along, and it is also why hundreds and hundreds of thousands of people find this sentence to be nothing short of appalling. Rikki, as always, we appreciate it.
Thanks, Josh.